His own brother stole the business, then lied about it for years. It started as a family business. It ended with a brother on the stand admitting he'd been lying for 3 years. The two men had built something real together. Starting in the spring of a decade ago, the plaintiff, the older of two brothers, had invited his younger sibling to co-found a residential landscaping company in a mid-sized Ohio city. The older brother brought the capital, the younger brother brought the clients. For 6 years, the business grew steadily, eventually generating just over $800,000 in annual revenue. By all outward appearances, it was a success story. Then, the younger brother wanted out. In the fall of what would become the final year of their partnership, the younger brother approached his sibling with a buyout proposal. He wanted to take his equity and leave quietly. The older brother agreed, and the two men signed a dissolution agreement that included a non-compete clause, a standard provision, their attorney said at the time. The younger brother agreed not to solicit existing clients or operate a competing landscaping business within a 50-mile radius for a period of 3 years. The ink was barely dry before things went sideways. Within 8 months of signing that agreement, the older brother began losing clients. Not slowly, not randomly, systematically. 17 of his 32 recurring commercial accounts canceled within a single quarter. When he started making calls, the story was always the same. A new company had reached out, offered better pricing, and the clients had made a business decision. The new company was registered under the younger brother's wife's name. The older brother filed suit seeking $312,000 in damages, representing lost revenue over the remaining term of the non-compete, plus legal fees. His position was straightforward. His brother had violated a binding legal agreement, hidden behind a family member's name to do it, and deliberately dismantled a business he had spent years building. In court, he was measured but visibly wounded. "I gave him his start," he told the judge. "I gave him everything he needed to walk away clean, and this is what he did with it." His attorney presented documented client records, time-stamped cancellation notices, and a side-by-side comparison of the new company's service offerings, which were nearly identical to the original firm's pricing structure and contract language. The younger brother's defense was more complicated and in some ways more compelling. His attorney argued that the non-compete had been presented to his client under duress, that the older brother had threatened to dispute the equity valuation unless the younger brother signed that same day, without independent legal counsel present. The younger brother testified that he had felt coerced, that the agreement had never felt fair, and that the company he had built through his own client relationships was effectively being held hostage. He also argued that the new company was legitimately his wife's enterprise, that she had always handled the administrative side of the original business, and that her decision to enter the market independently was her legal right. It was a credible argument. The judge appeared to be weighing it carefully. Then came the deposition excerpt that changed everything. During cross-examination, the plaintiff's attorney introduced a series of text messages retrieved through discovery, messages exchanged between the younger brother and his wife in the weeks before she registered the new company. In one exchange, dated just 11 days after the dissolution agreement was signed, the younger brother had written, "Use your name for now. Once the 3 years are up, we switch it back. Just keep pulling from the list." The list, the client list that had been the original company's proprietary asset. The younger brother had no credible response. He acknowledged the messages were real. He said, quietly, that he hadn't thought it would go this far. The judge ruled in favor of the older brother. Full damages were awarded, $312,000 plus $18,400 in legal costs. The non-compete was also extended by an additional 18 months as a punitive measure, a remedy the court deemed appropriate given the deliberate nature of the violation. The younger brother's attorney filed notice of intent to appeal, but the appeal was withdrawn 4 months later. No public explanation was given. The two men have not spoken since the verdict. Their mother, by all accounts, has refused to take sides. The original company has recovered roughly half its lost accounts. The new company dissolved within a year of the ruling. There is no clean ending here. There never is when family and money occupy the same room for too long. But here's the question worth sitting with. If the older brother had given his younger sibling more time to review that agreement, if he hadn't pressured him to sign that day, would any of this have happened at all? And if the answer is no, who really started this?